Welcome back to our page, everyone, and this video is about a notice of adjourned members' meetings. Now, adjourning the annual general meeting, a company should only consider an adjournment if it has issued its annual general meeting notice and does not have postponement provisions in its Memorandum of Incorporation. Now, generally, a quorate meeting is required to be held in order to enable an adjournment. However, the Memorandum of Incorporation will only permit greater flexibility, allowing, for example, for adjournment for lack of quorum, and the adjourned meeting must be held within 6 months of the company's financial year end, and so companies with a 31st December year end will have relatively little leeway. Now, adapting the annual general meeting, while the Chartered Governance Institute's initial paper included a number of matters to be considered when adapting an annual general meeting in light of current pandemic, the updated paper provides more guidance in the light of the government's compulsory stay-at-home measures, prohibiting, amongst others, public gatherings of more than 2 people. Now, while postponement of the annual general meeting is an option, companies may need to ensure that their standing share capital authorities, as granted at the 2019 annual general meetings, are refreshed before they expire. For certain companies, the ability to raise working capital by utilizing such authorities may be crucial in the coming months. This may determine in part whether a company takes advantage of any relaxation of the time frame within which an annual general meeting must be held, as it seems unlikely that any change to current legislation could extend the duration of shareholder-sanctioned share capital authorities. Also, companies may need to hold a general meeting on an urgent basis to approve a capital raising or other urgent transactions. Recognizing the necessity of being able to hold a valid general meeting issues like these while the stay-at-home measures persist, the updated guidance proposes an approach for companies who do not wish or are not able to postpone their annual general meetings. It recommends that companies encourage shareholders to vote by proxy and that they make it clear in the notice of meeting, RIS announcements, or by updating the information on the company websites where the notice of meeting has already been published, that public gatherings of more than 2 people are not permitted, and stress that anyone seeking to attend the meeting in person will be refused entry. Now, the guidance also offers advice on how to ensure that the meeting is quorate, who should chair the meeting, which directors will be allowed or expected to attend the general meeting, where to hold the meeting in the event of planned venue being unavailable or otherwise inaccessible. Now, ensuring the meeting is quorate. The quorum for a general meeting is typically set out in a public company's Memorandum of Incorporation or is determined to be 2 members present in person or by proxy as determined by the Companies Act. Now, this quorum may be satisfied by 2 directors and or an employee shareholders of the company attending the meeting, with resolutions being passed by the proxy votes of those who have not been able to attend in person, or by appointing one of those employees as corporate representative, and the votes of those in attendance. This might be achieved by, for example, an executive director and the company secretary being present at the general meeting, provided that each is a member, a corporate representative, or appointed as a proxy. The fact that their presence is necessary in order to or for a quorum to be formed means that their presence is essential for work purposes and therefore permitted, especially given they are both employees and the company needs to deal with the business of the meeting. Now, all or most of all companies should be able to form a quorate meeting in this way. Now, who should chair the meeting is your next question. The Memorandum of Incorporation will determine who chairs a general meeting. This typically provides that the chair of the board, or in the absence of the chair of the board, another director shall preside as chair of the meeting. It may be helpful for a director to attend as part of the quorum so that it is clear who shall act as chair of the meeting. Alternatively, the Memorandum of Incorporation may allow for any member to be elected to act as the chair for the meeting by a resolution of the company passed at that meeting. Now, to make sure that the chair of the meeting can exercise all proxies or all proxy votes submitted, companies should make sure that the form of proxy appoints the chair of the meeting and not the chair of the board or a specific director who may on the day be unable to attend. Now, which director should then attend? There's no legal requirement for directors other than those whose presence may be required to form a quorate meeting as I've described, to attend a general meeting, and their attendance would not be permitted under the stay-at-home measures. It would, however, be possible as an option for them to dial into the meeting if the company considers that this is helpful for the running of the meeting, although it is not required. Now, where to hold the meeting? Companies that have already convened a general meeting for a venue that has since become unavailable will need to find an alternative venue. If the company's Memorandum of Incorporation allows the board to postpone the meeting or move its location to an alternative venue, they should consider exercising this power to move the meeting to a more controlled venue, such as the company's head office. Now, while some companies may ordinarily have security concerns, especially if their general meetings are normally very well attended or if they operate in contentious sectors, the fact that the meeting may be held behind closed doors should mitigate these concerns. Now, companies that do not have a Memorandum of Incorporation, which enables them to postpone their meeting or switch to an alternative venue, should in law adjourn the meeting from the planned venue to an alternative venue. Where this is not practicable, companies should take advice on the best course of action in the circumstances, while always preserving the safety of the individuals involved. That is it for this video. If you guys want to know more, please do go onto our website, which is www.lawyers.easyfine.co.za. Also click on the like button or the thumbs up, give our video a thumbs up. Click on the bell button for post notifications for more videos like this, and then stay tuned for more videos.